Welcome to Judicial Dollars and Cents, brought to you by Anders Virtual CFO Services team from all across the United States. I'm John Scott, and in each episode, we'll shine a light on the financial side of the legal world, turning law firm numbers into impact-driven stories. From taxes and profitability to practice growth and leadership, we sit down with law firm innovators who are shaping the future of the profession. Let's dive in, right here on Judicial Dollars and Cents. Hey, welcome back to Judicial Dollars and Cents, the podcast where we dive into the business side of running a law firm. I'm John Scott with Anders Virtual CFO Services for law firms, and each week we talk with industry experts who help law firm leaders think differently about growth, profitability, and performance so they can build practices that last. Today we welcome Don Foty. Don is the founder and managing partner of Foty Law Group. It's a Houston-based law firm focused on complex litigation, including employment class action, wage and hour disputes, and significant personal injury matters. It's a firm widely recognized as a national authority on wage and hour laws and Fair Labor Standards Acts. Also, Don has served as class counsel in more than 100 wage and hour class cases and collective actions across the United States. Throughout his career, courts have repeatedly recognized his skill, experience, and success in employment litigation. Don, welcome to the show.
Thank you for having me.
Hey, I love to hear people's origin stories. So tell me how you came from a finance degree at UT into what you're doing today.
Yeah, so it's kind of it's not the most interesting story, but I was studying finance at the University of Texas. And I think like most college students, when they are about to complete their undergrad, the choice is either, hey, I graduate from college and I get a job, or I go to graduate school. And I think it was my mother who kind of pushed me towards going to law school. My older sister at the time was in medical school. And so she, basically kept saying, well, I need a doctor and a lawyer in the family. So it's time for you to go to law school.
So your mother's set now.
Yep, exactly.
Well, that's awesome. And at your firm, we like to set cash targets for firms. And we say between 10 and 30% of annual revenue is the target. And the difference being between those two goalposts is your risk. Now, when you're doing class action suits and PI work, those are higher risky areas. So your cash needs are greater. How do you handle feeding the investment that you need for those cases?
Yeah, so you need to have sufficient cash flow to run the firm. So unlike a law firm that bills by the hour and gets paid monthly by their clients who simply pay their hourly billables, when you're running a complex litigation firm, your cash flow could be great one month, low another month, or it could be low for a few months until your case is settled, because you don't get paid until there's a recovery on the case. And that's when the attorney's fees come in. So you could go months at a time running a contingency fee practice, which is what we do. We charge a contingency fee. We get paid a percentage of the recovery if we achieve a recovery for the clients. So you could go months at a time without having any income coming to the firm. So you need to have sufficient cash reserves on hand to pay your bills, to pay any marketing expenses, to pay your employees, as well as pay for what's called the litigation expenses of the cases you're handling. So when you run a contingency fee practice, you not only get paid when there's a recovery, but you also have to front in advance all of the litigation costs that are going to be incurred in the case. So every time there's a deposition that's taken in the case, that costs money. Every time you need to hire an expert, that costs money. Every, filing fees cost money. Service fees cost money. Ordering records cost money. So all of those expenses that are needed to litigate a case, to gather the evidence, to prove the case, those expenses typically are fronted or advanced by the law firm. And so you need to have sufficient cash reserves on hand to estimate the cost for the litigation costs, as well as to pay your operating costs.
And as John Morgan says, that's his money. So then in this case, that's your investment in those cases.
That's correct.
And of course, that sits on your balance sheet. And when the case settles, you're going to get that money back. But
right.
We're working with a firm in the Southeast right now that really had a great year, but their case volume has been growing and their prepaid case costs went up $700,000. So when we looked at income in December and said, hey, you had a great year, income and cash flow are two different things because they've got 700,000 of additional dollars tied up on the balance sheet. And so when we look at distributions, they go, how come we don't get the bigger number? Well, you're going to get it. It's just a question of when those cases settle.
Right.
And as you continue to grow, it's just going to get bigger and bigger.
Yep. Yeah. Your litigation expenses, that could be a significant, that can tie up a lot of your cash.
Do you ever use a line of credit or any other debt structure to finance?
Yeah, we do. The firm does have a line of credit. I think that's helpful. We don't charge the interest on the line of credit to any of our clients. We eat that cost ourselves. But yeah, I mean, it's helpful to get that additional cash flow. But yeah, you have to set aside you really have to have set aside sufficient cash reserves to basically run your firm.
I know some mass tort firms, and I suspect some class action firms do it as well, have access to non-recourse debt. And so you have investors that will take bets on these large mass tort cases, and they get a nice kicker when the case is won. But if it's not won, then the debt's forgiven and there's no harm, no foul. But, there's always a payoff and real cost when that money does come in and get paid.
Yeah, that's the term for that is litigation financing. I know Georgia just passed a law banning all litigation financing. So some states are cracking down on that. But yeah, generally speaking, the collateral for the debt that you for the cash that you receive is the right to recover on those cases. So that could be useful to a firm. It may not be useful to a firm because they do come with significantly high interest. Significantly high interest.
Well, and not only that, because it's non-recourse, if you do happen to not prevail and you don't have to pay it back and you've spent that money, right? Yep. Now you have what really is phantom income because that debt is forgiven and it's problematic.
Right.
With your finance background and in a contingent environment, it's easy to forecast in an hourly billing firm, right? I charge hours, I send out bills, I collect money. How, if at all, do you try and forecast revenue and cash in a contingent environment?
Yeah, so I have cases that are basically in 3 stages. I have cases listed that are in stage A, which is we just filed those. I have cases listed that are in stage B, those are cases where we're in active discovery. And then I have cases that are in stage 3, which is we're in active settlement talks, or the cases have settled, but we've not received approval of the settlement. So most of my cases involve class actions or collective actions. And when one of those cases settle, we have to submit the settlement agreement to the court and we have to go through a court approval process. And that court approval process could delay the law firm receiving payment on the case for 6 months to a year. So we have essentially we have several of those cases that are in that, hey, we've settled them, we've reached an agreement in principle with the defendant, but we've not received court approval. So having cases that are in that bucket C, where they've settled, they're in the settlement approval process, or they're in some part, or they're about to settle, that enables you to, hey, I can forecast that within 12 months, I should be receiving X dollars on those cases. And then you can forecast, okay, now let's look at the category B cases. Of those category B cases, which of those, based upon what you've done and what you've learned in the case, are realistically going to settle within the next 12 to 18 months, maybe 24 months, and you can kind of forecast your revenue from those cases as well. So I think you can, if you handle it right, you can forecast, expected revenue within, for the next year to 18 months pretty confidently.
I love the fact that that's your thought process because we go down the same path. It's like, the types of cases you'll accept, what their values are, and the values could change over time. You also know those milestones. So you can build out a framework or a spreadsheet and say, okay, here's where the buckets of cash will come in. And all it really takes once it's built is someone looking at it on a regular cadence to update the amounts or the timing. Once you get a settlement in a class action, your work is not even near complete because now you have to calculate the payments to all the the parties in the class, right?
Yeah, I mean the biggest component you do have to calculate. Either my law firm will do the calculation, or there's a third party administrator who'll do the calculation. But you're right, that's definitely one component of it. The bigger component of it is the court approval process. So you have to draft all the settlement documents. That could take a month or two. Then you have to draft the motion for approval. That could take some time. Then you have to submit all that information to the court, and the court, depending on the type of settlement, whether it's a class action or a collective action. If it's a class action, you have to go through a two-step process. You have reached a preliminary. You have to ask the court to grant preliminary approval of the settlement. So the court reaches a decision. We're going to preliminarily approve the settlement. Then a notice has to go out to all the class members advising them of the settlement. That's usually 60 to 90 days. Then if there's any objections to the settlement, you have to address the objections. And then you have to go through a final approval process where the court considers all of the information that was gained from the preliminary approval process, the notice process, and then consider all of that final approval to decide whether or not the court is going to grant approval of the settlement. And then after the final approval, that's when you have to wait normally around another 30 days, then you can get paid. So it's the reaching the settlement, that's just, that's good that you've reached it in principle with the defendant, but you're just you're still about middle of the way there to getting paid on that case.
It's like that old ad where the old man's got the fishing pole with $1 tied to it and it's hanging there, and he pulls it back. Oh, you got to be quicker. So you get the settlement, and then you still got to go through all these.
You still have to go through the process of getting
everybody paid.
Right.
Hey, let's switch gears a little bit. The last few years, AI has been all the rage. It first came out and attorneys were like, oh my God, this is going to be the ruination of the profession. I still think there's a few people that feel that way, like the civil defense guys, they feel that way. And probably rightly so, because the insurance companies are putting a lot of pressure on them, even before AI, to charge less time, charge lower rates. But how, if at all, is your firm using AI in what you do?
So we are not using AI to supplement any actual legal work. So we don't use AI to draft our briefs. We don't use AI to draft, frankly, any legal document. Where we use AI is mostly on the administrative front. So, and I've talked to a lot of lawyers who use AI to, hey, help design your website, or hey, create sort of administrative summaries. What are all the cases that have been on file for 6 months that have not settled, and AI can pull a report on that. So a lot of the administrative functions that a law firm needs to run, that's where AI can come in. But as just as a replacement to a lawyer doing their legal work, drafting the necessary motions, presenting the arguments to the court, no, we don't use that. We don't use AI at all for that. And I think the lawyers who have used AI to replace actual legal work or to supplement their own legal work, they've gotten in trouble with the courts. I mean, AI is not perfect. AI has a lot of glitches, and lawyers who follow up with the legal news have inevitably seen lawyers who've gotten sanctioned for submitting briefs to the court where AI has cited fake cases or fake quotes or made up stuff. So I think if a lawyer is out there using AI to basically do the legal work for him, you run a big risk that it's going to make a mistake and you're going to get in trouble. And there are several courts that I'm aware of that have issued standing orders that said you cannot use AI to help you draft any legal documents, and you have to certify that you've not used AI. And in fact, we just recently amended our employee handbook to specifically state you cannot use AI to do legal research or to draft any documents for you. But you can't have it. It's not being used for legal work, but that doesn't mean administrative work. Purely administrative work, that's non-legal work, AI can't supplement and AI can't be important. And I think that's where AI can provide some benefits and some efficiencies.
Right. And I think that's a great use case to create those efficiencies, to allow folks to do higher level legal work in the firm, because you're taking repeatable processes and you're automating them, letting AI do that. It's not the legal work, but that frees up the time for folks to focus on more complex legal matters.
Yep. Yeah. I think we had a PDF document that we got produced in discovery, and for some reason, we couldn't OCR it. So we had AI take the data that's in the document and just add it to a spreadsheet, and it did that, and it did it pretty easily. So normally it would take a paralegal several hours to manually type in the data from a PDF document and manually put it in a spreadsheet. AI did it in a matter of minutes. So those types of efficiencies, I think you can get from AI, but as pure replacement for lawyer work, absolutely not. I think I think lawyers want a real risk of AI doing it wrong and lawyers getting in trouble.
Completely agree. And anytime you're rekeying something, you have the tendency to fat finger something, make a mistake,
right,
where AI can do it automatically, and then you can spend your time proofing it.
Right. Yep.
So what case management system does your firm use to track cases?
So we use Smart Advocate. It's
Okay.
it's a litigation heavy case management system.
So back to my theme about not rekeying things, how does that integrate with your accounting function? Does it feed right into your accounting system?
It actually, well, no, it doesn't. But that's probably something that we can improve upon. Yeah, most of the accounting is done, the old traditional way through QuickBooks. We have manual entries in QuickBooks. We have journal ledgers that keep track of every single transaction, every single credit card payment, every single inflow and outflow is tracked and recorded. So, but we do that kind of the old-fashioned way. We have an accountant who's on staff who basically has every single transaction documented and recorded in QuickBooks.
Well, I'm going to suggest another use case for AI, in that you find an AI person or an AI product that will write the code that will go into the APIs of your case management system and then create a bridge to QBO, because that will cut down on the fat fingering of errors in the entry that you have.
Yep. Yeah, that's a great idea.
So, hey, class action lawsuits are often misunderstood by the public. From your perspective, what are some of the biggest misconceptions people have about employment class claims and wage claims?
Yeah, so my firm primarily focuses on class actions that involve workers. So when I talk to people about class action, like worker class actions, the biggest misconception is they assume it's kind of like a consumer class action, where they're going to get either a coupon in the mail or they're going to get 50 cents in the mail, and that's not what these cases are. These are cases involving real dollars, workers who were denied wages, and there's real money at issue. So I've seen cases. There have been class actions I've been involved with where the average payment has been $12,000 to the class members. So now you've got a person who gets a check in the mail for over $10,000 because they were involved in the class. So that's a lot different than, hey, you open up your notice and you're getting a coupon because something was misrepresented to you when you bought an item. So
I laugh a little bit at that, because we'll get that thing in the mail says, hey, you could be in this class, and my wife says, should we sign up for this? I'm like, no, we're going to get a Valvoline coupon, and no, I don't want that.
Yeah, and so the misconception is class actions always result in coupons or just small pennies. But no, when it involves workers, there's real money at stake. There's real money that's owed, and we do our best to try to recover the maximum amount we can on cases so that these workers can get paid what they're owed.
So what are some of the things that what are some of the claims against employers that are typical that would create a class, actionable class?
Yeah, there's lots. I mean, this is the whole area of the law. Let me just give you just a couple of examples. So let's say, well, I'll just give you a real life example. So COVID happens, right? COVID happens, in 2020. We get the country is under lockdown, and we've got COVID mandates in the States. So companies like Amazon and Walmart, they stayed in operation, but they required their workers to, Amazon in particular, required their warehouse workers to pass a COVID screening before they clock in. So they're on the premises of the employer. They're required to go through a COVID screening. They're lining up, and one by one, they have to go pass a COVID screening. So that's, time every single day for every single worker during the entire period where these COVID screenings happened that they weren't being paid for. So that was a class action that we brought saying, hey, you should reposition the time clocks at the front of the line so that they're clocking in while they're waiting in line and going through the COVID screening, as opposed to after they pass it and then they have to go walk to the time clock. So that's a real case. Another real case would be workers who they're paid a salary, and a lot of times workers believe that, hey, if you're paid a salary, you're not eligible for overtime. Well, that's not exactly actually true. So to be exempt from overtime under most exemptions, you have to be paid a salary of a certain amount, which is a guaranteed amount, and you have to do certain job duties that qualify for an exemption. And so if there's a position in a company that's a salaried position, but the workers in that position don't do the job duties that qualify for the exemption, well, then you could bring a class action or collective action arguing that the workers in that position are being misclassified as exempt from overtime when they really should be paid their overtime. So that's another example.
So really the HR department that's not doing their job in writing those job descriptions and applying them, so that because they're lazy or not aware, are putting the company at risk for a litigation.
Well, I mean, it's that could happen. Yes. It could be that they just really haven't updated their job descriptions. So let's say the job description was written 10 years ago, but what the day-to-day functions of the job have changed, and they haven't actually looked into what these people are doing on a daily basis with changes in software, changes in technology, changes in the workforce, what these workers are doing on a day-to-day basis. Maybe HR, which is in one state, doesn't know what these workers on the ground are actually doing in another state, and they don't get that feedback, and they don't do regular audits to find out whether these workers really should be classified as exempt or non-exempt. That could be an example. Another example could be, and this is pretty common, where employers, some unsophisticated employers, say, hey, I can avoid paying overtime by simply calling all of my workers independent contractors, when really under the law, they should be classified as employees. And if they're employees, they're entitled to overtime. So that could be an example of a case. So it just depends. There's lots of these cases there's lots of legal issues that arise when you're dealing with the wage and hour laws.
Well, you're so right. And I see that when companies merge, and all of a sudden you're bringing on a bunch of new people who are in different states. And then post-COVID, people work remotely. So,
right.
You didn't think you had the issue because you're based in Oklahoma, but now you've got employees in California. And so the rules about PTO are different there. You can't cap it. And you really have to be a sophisticated HR department to handle those remote employees and mergers.
Well, let me give you another example. I think and this ties into AI. So let's say you have a lot of companies who are now adopting AI programs. And now a lot of the decisions that used to be made by humans is now being made by AI. So it's AI that makes the decision. It's AI that's deciding whether something should happen. And so there's an exemption from overtime for a salaried worker called the administrative exemption. And one of the requirements for the administrative exemption is that, hey, the worker exercises independent judgment and discretion regarding matters of significance. And let's say the worker did do that before AI. But now that there's AI, that judgment and discretion is gone because the AI program is making it. Well, now that worker may not qualify for the exemption from overtime. You got to pay overtime to that worker now because his job is essentially changed.
Wow, there's landmines everywhere here. Hey, before we get to the end here, I want to ask you about Texas football and how your experience is in. Has it been a welcoming experience in the SEC, or? And before you answer, let me give you my background. So I went to the University of Missouri. We've been in the SEC for a while, but we had this great conference called the Big Eight, and you played 7 games a year against the same opponents, and you had a big part of your schedule where you could play other good teams. I mean, in the late 70s, we played Notre Dame. Okay. And then it expanded to the Big 12 with the addition of Texas. and then the Big 12 kind of blew up, and we ran to the SEC, happy to be there, and all of a sudden Texas and Oklahoma are back. So what's been your experience with the SEC?
Well, I will say this. I think everybody there were a lot of people who didn't go to Texas, who did not like that Texas was moving to the SEC. And, I heard from everybody that Texas is not going to be able to handle the SEC. They're going to get steamrolled when they play all those teams with those great defenses. And I'll say this, I'm happy with the way Texas's football team has been looking.
You guys had
a down year last year.
You certainly responded, though. I mean, you didn't embarrass yourself.
No. I mean, the first year that we played in the SEC, we were in the SEC championship game.
Right.
So, I mean, you can't. I mean, come on now. I mean, that's pretty good.
Now, what's going on with Arch, though? I mean, he was the tale of two quarterbacks. All of a sudden, he looked like he was confused and dazed, and then all of a sudden, he looked like what we expected.
Yeah, so he started off really slow. I was actually at the Ohio State game, the first game of the year, and I think it's a lot of pressure for a young quarterback to start. And your team is ranked number 1 because Texas was ranked number 1 at the time, and they were playing the number 2 team in the country, Ohio State. And then you got to go to Ohio State to go play your very first game that you start. I think that's a lot for a young quarterback to take on and to handle. And Texas only lost by 7 points at that game. So look, I think the first half, I think he wasn't sure of himself, and I think he was making poor decisions just because he was overthinking it. And I think at in the second half, he turned into a completely different player, and I think we're going to see that carry over. I think Texas is going to have a really good team this year.
Well, Sark's a good coach. Arch is going to be good. I think you'll have a good year, and I'm happy to have you in the SEC. I think it is the best conference, even though the Big Ten is eating our lunch right now with all their NIL money, and Indiana, that's a flash in the pan.
Yeah, Indiana. I mean, they came out of nowhere.
Well, Mark Cuban money helped that too.
Yeah.
Hey, before we wrap up, how can folks get a hold of you and your firm?
They can go to my website, which is www.fotylawgroup.com. Foty is spelled F-O-T-Y. And they can obviously always call us 713-523-0001. And if there's a worker out there who has questions about their pay records, or questions about something that happened at work, or they just can't even understand what's written on their pay records, they can give us a call, and we can see if we can help them out.
Well, thank you so much, Don, and thank you all for tuning in to Judicial Dollars and Cents. If you enjoyed today's episode, be sure to like, follow, and subscribe wherever you listen to podcasts. It helps us grow and ensures you never miss an episode. We'll see you next time on Judicial Dollars and Cents.
Thanks a lot. Thanks for having me.
Thanks for joining us on Judicial Dollars and Cents, presented by Anders Virtual CFO Services. If you found value in today's conversation, be sure to follow or subscribe wherever you get your podcast. To learn more about how Anders helps law firms strengthen their financial foundations and drive growth, visit anderscpa.com. Until next time, keep making smart decisions that make perfect sense.